Most people assume a wedding ceremony automatically creates a binding legal marriage. They imagine the exchange of vows is what binds them, never seeing the rigid geometric web of legal contracts that actually forms the union. But the family law system in England and Wales operates on absolute strict compliance. A legal union requires exact adherence to statutory rules. Long before a lawyer addresses the division of assets, they must first verify if a legal union was established in the eyes of the law. A defective marriage falls into a highly specific spectrum of failure. A union might be legally classified as voidable, void, or categorized entirely as a non-marriage. We are going to map the exact mechanics of valid formation and dissect the financial paradox of the legally invisible void marriage. Assuming a ceremony equates to a valid marriage without verifying the legal architecture is the most dangerous error a family law practitioner can make. This diagram illustrates the two separate statutory frameworks required for a valid marriage: capacity under the Matrimonial Causes Act 1973 and formalities under the Marriage Acts. Let's examine capacity. These are the rules dictating who is legally allowed to marry. First, following the 2022 Act, both parties must be at least 18 years old. There are no exceptions. Second, the parties cannot fall within the prohibited degrees of relationship. This restricts marriage between close relatives, whether by blood or by a former marriage. Finally, both individuals must have single status. English domicile law strictly prohibits bigamy and polygamous marriages. If capacity governs who can marry, formalities govern exactly how the marriage must be enacted. The process begins with civil preliminaries. Couples must give formal notice at a district registry office exactly 28 full days before the ceremony. The location is equally restricted to approved premises. When Prince Charles married Camilla in 2005, the civil ceremony had to be relocated here, to the Windsor Guildhall, because licensing Windsor Castle meant opening it to the public for 3 years. And finally, the ceremony must be conducted in the presence of an authorized celebrant, such as a registrar or a recognized religious official. A valid, legally recognizable marriage exists exclusively when both pillars, capacity and formalities, are completely compliant. Watch what happens to our structural model when one of these foundational requirements is critically compromised. The legal outcomes diverge sharply. The first outcome is avoidable marriage, governed by Section 12 of the Matrimonial Causes Act. Avoidable marriage is entirely valid until a court formally annuls it. This action occurs due to specific post-ceremony discoveries, such as non-consummation or lack of valid consent. The second, far more severe outcome is a void marriage, governed by Section 11. A void marriage is an absolute legal fiction. From the perspective of the state, the marriage never existed. This classification results from severe capacity defects, like marrying a close relative, or a deliberate, knowing failure to comply with the required formalities. The distinction is precise. A voidable marriage was a legal union until challenged, whereas a void marriage was a legal nullity from day one. Yet establishing that a marriage is void is often a highly desirable outcome for a separating couple when looking at the alternative. For a lawyer, determining whether a marriage dissolves via proactive legal erasure, or if it was simply a ghost from the beginning, dictates every strategy that follows. This split screen captures the paradox. A void marriage never legally existed, but the Act still grants both parties standing to apply for massive financial and property orders. But there is a third, dangerous category on the right, the non-marriage or non-qualifying ceremony. A non-marriage lacks so many basic formalities that it fails to even qualify for the statutory protections of a void marriage. To see where this boundary lies, we compare two cases. First, the void example, the 2013 case of Assad v. Kurder. Here, the couple underwent a foreign religious ceremony with technical defects regarding notice and registration. The judge ruled the ceremony was not so deficient as to be a complete non-marriage. It was void, meaning financial remedies remained accessible. Contrast this with a strict appellate decision from 2020, Akhtar v. Khan. This couple underwent an Islamic nikah. They lived together for 18 years, raised 4 children, and presented themselves to the world as husband and wife. But the court found a wholesale failure to comply with the English Marriage Acts. There was no formal notice, no certificate issued, and no registrar present. Despite nearly 2 decades of shared life, the court classified the nikah as a non-qualifying ceremony. It was legally invisible. Because the relationship was a non-marriage, the applicant was completely barred from applying for any financial remedies under the Matrimonial Causes Act. This precedent terrifies modern practitioners. 18 years of shared life and intention carry no financial weight if the ceremony is classified as a non-marriage. This final matrix maps the entire spectrum of formation directly against the financial stakes. Valid, voidable, and void states all grant the family court jurisdiction to redistribute wealth, but the non-marriage is a legal black hole. Establishing court jurisdiction depends entirely on these formation rules. Without them, the legal machinery for financial redistribution cannot be engaged. Before calculating assets or valuing pensions, a practitioner must ruthlessly interrogate the exact legal architecture of the wedding ceremony. Failing to identify a non-marriage early in a case leads directly to catastrophic financial surprises for a client. The family court holds immense power to achieve financial fairness, but that power is accessible only through the strict statutory mechanics of formation.